Now, meanwhile, Joe Biden is out giving a harsh message to the media. He's talking to the media, and Mediaite, which is no right-wing website, says that Biden offers a grim Thanksgiving message. Could it be grimmer than like a winter of suffering and death or whatever he said? Take this pharmaceutical, or you're going to have a winter of misery and death. Thanks for leading us, Mr. President. So now he's back this Thanksgiving holiday. Says Thanksgiving message warns journalists of a tough job ahead because alternative media, like live streamers on YouTube, are taking their jobs. Biden lamented the, quote, exceedingly small number of people tuning into the mainstream media, saying that they have a tough job ahead of in a message for, quote, worried Americans. He went to Nantucket on Tuesday with his family on Air Force One. He's like, you guys are doomed. You know that? The president addressed journalists who asked him whether he had a response for Americans who were worried about the future this holiday season. Biden's response was less than optimistic. He says, my message is to just remember who we are. That's a Biden. Look, you'll have a very tough job. I'm not being solicitous. A really tough job. Think about it. I remember a couple weeks ago that survey done how people, they feel about where they are. 62% felt they're doing pretty well. Asked what they about the direction of the country, only 35% said we're moving in the right direction. I think there's an explanation for that. Then Biden pivoted. He said, this is not a criticism of the press. You know me too well. When you turn on the television, people don't see a lot of good news. Even stuff that is good news doesn't seem to sell very well. And so when you turn on TV, everything looks bad. Everything. And now you have to deal with because a lot is bad. And now you have to deal with the exceedingly small number of people watching mainstream television and reading the newspapers because they got lied to by the people on TV and writing the newspapers. I forget the number. You know better than I would, but the numbers are way down, says Joe. So where do you get your news? X, how do we know your hearing is not what you're just looking for as opposed to what's really happening, or they're fixing up the transcript? Not because of you. I'm not being critical of the press. Then talking about Joe, he says about Trump, I want to make sure this transition goes smoothly. I make sure it goes smoothly and all this talk about what he's going to do. I think there may be a little bit of internal reckoning on his part. So it remains to be seen. All right, whatever that means. All right, here's a little bit of that.
Mr. President, there are many Americans who are worried about this huge holiday season. What is your message to them?
My message is to just remember who you are. Look, you'll have a very tough job. I'm not being solicitous. A really tough job. Think about it. I remember a couple weeks ago the survey done how people feel about where they are. 62%, 35% felt they were doing pretty well. What do they think about the direction of the country? 35%, only 35% so far moving in the right direction. I think there's an explanation for that. If you think about it. And it's not a criticism of the press, this know me too well, is that you turn on the television, you don't see a lot of good news. Even the stuff that is good news doesn't seem to sell very well. You turn on the TV and everything looks bad.
All right, so I read the rest of it, but that's what the president looks like. Pretty rough, but he's right. They are having a difficult time out there in the media. Maybe they shouldn't have lied to everybody about the science and the border and the economy and the dollar and war. And maybe they'd still have some trust and credibility left. All right, but they don't. All right, so my friends, let's turn our attention over to Tish land in New York because we have a filing that just dropped or just broke, just was published, that came out from D. John Sauer, who's going to be our new Solicitor General for the Trump administration. And here is the segment. Right now, we've got the filing. Trump's team now demanding that Tish James, the attorney general in the state of New York, who brought forward the civil fraud claims against the president that resulted in a nearly $500 million judgment, which is now up on appeal. She is getting a letter from D. John Sauer. You may remember that name because he's going to be the new Solicitor General for the Trump administration. And we've listened to a lot of D. John Sauer here, a brilliant individual and attorney. And you've heard his voice here arguing in the Supreme Court and elsewhere. And he's got that raspy voice. This is what he looks like. And he is bringing this letter to Tish. Before recently, he was just a lawyer for Trump. Now he's going to be the nominee for the Solicitor General. Very powerful position, responsible for very important things. And he's a good candidate for it because he's got a ton of experience in these courts. And so now he sent this letter to Tish. And you remember Tish, she's this attorney general who ran for office in New York saying that she was going to stop Trump. After Trump won re-election, she came out immediately and said she's going to fight Trump. And now she's getting a letter saying Trump is going to be the president. And his Solicitor General is now sending you a memo saying, all right, Tish, November 26, published recently from the James Otis Law Group from D. John Sauer. They say, all right, Attorney General Tish, this is the civil fraud case that you brought against Trump, saying, Dear James, in furtherance of our conversations with your office, we write to request that you, Tish, completely dismiss the above referenced case against President Trump, his family, his businesses, and you stipulate to vacate the judgment and to dismiss all claims with prejudice, meaning you're not filing these back ever again. And you will stipulate and agree to do that. In the aftermath of this historic election victory, writes Trump's defense, President Trump has called for our nation's partisan strife to end and for the contending factions to join forces for the greater good of the country. This call for unity, Tish, extends to the legal onslaught that's been brought against him and his family that permeated the most recent election cycle. This case, like many others against President Trump, is a flashpoint of national partisan division. As counsel for President Trump in his appeal, D. John Sauer, and now as his nominee for Solicitor General of the United States, I have had the opportunity to experience this partisan division personally because he was representing Trump against it. And I strongly believe that it is necessary for the health of our republic for the strife and the lawfare to end. You, Tish, now have the singular opportunity to help cure this division. Other Democratic officials and prosecutors are abandoning their discredited lawsuits against President Trump, Letitia. For example, just yesterday, Jack Smith's office, not even a real boy, moved to voluntarily dismiss its criminal case against President Trump in D.C., as we read here. Judge Chutkan, the district court, granted that motion and dismissed the case the same day. Didn't even have to think about it. Jack's office also moved to voluntarily dismiss its criminal case against President Trump in the appeal in the 11th Circuit in the Florida classified documents case that Trump won after Judge Cannon, the federal district judge there in Florida, dismissed the case because Jack Smith is illegally appointed and was never supposed to access millions of dollars that he did to prosecute Trump. Today, the 11th Circuit granted that motion and also dismissed the case against President Trump. Now, similarly, the DA's office of New York, that's the Alvin Bragg prosecution with Judge Merchan, consented to postpone all pending deadlines in its criminal case against President Trump. And on November 22nd, the trial judge, Merchan, adjourned the sentencing indefinitely. And we read all of that here, and it was incredible. And it was them not admitting they were doing this, but they're just like, we're just going to reschedule the sentencing. We're just going to have an evidentiary hearing now. Okay. So you're vacating the sentencing? No, we're just changing it a little. So it's gone? Yeah, it's gone. All right, that's what I thought. While granting President Trump to leave to file a new motion to dismiss. Yeah. So this case, Letitia, else is doing it, warrants the same treatment. Now, as detailed in our appellate briefing, this action exceeds New York Attorney General Tish's authority as detailed under the law, stipulating to the vacature of the judgment and the dismissal of the case would restore Tish's power to its more legitimate scope. And let's pause for a quick second because remember this exchange, which was in the Court of Appeals. This was during the appeal process. So this case is currently on appeal. if you recall, the judgment from Judge Areola Angeron, the judge who gagged the president so that he could not talk about him and his Greenfield, his GF, who was sitting right next to him on the bench. We don't know what they were doing up there on the bench. We couldn't see beneath their necks, so we really couldn't tell what they were doing, if they were passing notes, what was going on with their hands, what was happening there. We don't really know. And then when Letitia was in the courtroom, she was sitting back behind the bar. Remember, we covered this whole trial. We were reading through the excerpts courtesy of Inner City Press, and we were reading through it, and we saw that she was behind the bar, not even up front with the team because she wasn't really doing anything. And then she also took her shoes off in the courtroom. Alina Abba was like, Your Honor, she's stinking up the whole building. Then they moved the cameras, away. So when they were complaining because the judge's GF was allegedly passing him notes, they turned the cameras away from the benches so nobody could even see. That's according to Alina Abba. Insane trial. We had a bunch of people who were actual perjurers come in there and testify, like Michael Cohen, who lied on the stand in the middle of that trial. Or he lied to a federal judge in another case when he took a plea deal, because Alina Abba was asking him about that, and he got caught in a lie again, and the judge didn't care at all. So the case was a sham from the beginning, but resulted because of Areola Angeron, the judge who was sending bonus torso photos to his email newsletters showing people his 70-year-old nipples for whatever reason, was sending that out to everybody. He was the judge, hates Trump, wrote it in his newsletter about how he hates Trump. $500 million judgment sent shockwaves through all New York. Everybody freaked out about it. Kevin O'Leary, Mr. Wonderful's melting down. What are we going to do with our businesses? Because this was a private deal between Trump and a bank. There were no victims at all. The bank did their due diligence. Trump had disclaimers in his financial statements that explained that this is our analysis. You should do your own due diligence. They did. They did business with him multiple times. Nobody lost any money. They made a ton of money. And so it was all just a political attack. Now, the Court of Appeals in New York caught that. Just as a quick refresher, this is what they said before we go back to Sauer.
May it please the court, Judith Vale for the New York Attorney General's office. All of the defendants repeatedly violated...
Ms. Vale, can you identify any previous case in which the Attorney General sued under Executive Law 6312 to upset a private business transaction that was between equally sophisticated partners, where the supposed victim had the ability and legal obligation to discover the allegedly misrepresented matters by conducting its own due diligence, where the supposed wrongdoer advised the supposed victim through written disclaimers to conduct its own due diligence and to draw its own conclusions, where the alleged misrepresentation almost entirely concerned inherently subjective valuations of properties and businesses.
Yes.
And where the victim never complained about any fraud in the transactional losses from it. Because I've gone through the cases which you've cited, and all of them always involved the consumer protection aspect. It involved protection of the market.
And I want to add to his question, and little to no impact on the public marketplace.
Okay. So that's what you call a legal backhand by a Court of Appeals bench, and beautiful, right? So that is what we said. Okay, we're on appeal. Sounds like the Court of Appeals is in agreement with them. And so, Tish, your case is crap. Even the courts think it's crap. The only people who appreciated it were Tish, Angeron, Areola, and his GF in the courtroom. So here's what they say. They say, okay, first, look, the statute of limitations bars claims and liabilities. These cases are too old. The Supreme Court evaded that problem. And remember, we're in New York, so the Supreme Court, this is Angeron, the Areola, aka the NIP, evaded that problem only by disregarding their clear instruction that the continuing wrong doctrine does not delay or extend the limitation period. So pausing on this issue briefly, they were saying Trump did bad business deals. Okay, he entered into a contract, let's say with the bank. Trump engages with Deutsche Bank for a loan on a property. That loan was in, let's say, 1995. That's way too old. If you had a problem with that loan, the AG should have done something about that within 5 years of that, or 7 years, or whatever the statute of limitations is. But Angeron said, because we found what we think is a new violation that's much more recent, let's say like in 2022, or this is a Trump case, let's say 2019 or 18 or 14, because it's a continuing wrong, it's the same thing that happened before. We can go all the way back to the 90s and bring in all of those other claims. Now, the Court of Appeal says you can't do that, but Engoron did it. Ignoring that direct binding instruction, the Supreme Court, Engoron, erroneously and disrespectfully applied, this is Trump's defense, the continuing wrong doctrine to resuscitate a long defunct claim, Tish. This led to an indefensible judgment that directly violates the statute of limitations. It's too old, it's expired. The case should be dismissed on that basis alone. And this is a legal component. It's a technical sufficiency requirement that you are not meeting, and you should dismiss it law. Moreover, the case involves no victims from the banks, no complaints, no misstatements, no causation, no injuries or losses at all. Instead, President Trump provided clear and unambiguous disclaimers to a sophisticated commercial party who made decisions based on their own due diligence. Every loan and insurance payment was made in full, either on time or early. President Trump's business partners were delighted with these transactions. They benefited enormously, making over $100 million in profits. The actual participants to the transactions described President Trump and his business as, quote, tremendous, as, quote, visionary, sensational, superb, quote, a highly probable success story, and creating, quote, a long and satisfactory relationship. Now, no evidence supports any finding that the alleged, quote, misstatements were in fact misstatements at all. And Tish was saying he overstated his square footage in one of his buildings, or he said this was more valuable than it supposedly was. And Trump said in the statements where he made those claims, this is my opinion of these things. Go do your own due diligence. They say they had no capacity or tendency to deceive that's required under the law. In fact, the opposite is true. The evidence definitively demonstrates that the Trump counterparties, okay, the banks, were not deceived at all. They did perform their own due diligence. They eagerly sought and they embraced these business deals. They were highly profitable to them. And that these statements that Tish said were misstatements weren't at all. As noted, the loans were paid back in full, on time or early. But worse still, the chilling effect generated by this case is crushing to businesses across New York who are being forced to flee to friendlier states where such standardless enforcement and excessive punishments are not found, where you can be subject to Tish's tyranny at any moment because she just wants to come after you. Indeed, as many people of our supporting amici, friends of the court who file friendly briefs supporting these legal claims, they say, they're filing with us, Judge. This case continues to deter investment. People are not coming to New York to build buildings here. And it's causing money and capital to leave in droves. And moreover, Engoron's valuation decisions are indefensible. If you recall, Areola, we'll get there, said that Mar-a-Lago was worth $18 million. Obviously, that's insane. The unrebutted expert testimony, Tish, in this case, demonstrates that President Trump's statements were consistent with the GAAP principles. And we spent a lot of time on this during the trial, the generally accepted accounting principles, GAAP. GAAP explicitly permits the wrongly alleged misleading estimates in this case. You said that they were misleading? Wrong. The principles, as written, allow us to do exactly what we did. And we know this because expert witnesses from the new NYU Stern School of Management came in and confirmed it in trial. Now, by contrast, Areola Engoron, the judge, failed to cite GAAP or any other objective standards to support its findings. What were they relying on? Engoron used a subjective standard. He just said, I know it when I see it. Ugh, so do we. And we saw your emails, Judge. As a result, the judge and the judgment sends shockwaves through the marketplace by indirectly and incorrectly deeming GAAP-compliant disclosures as fraudulent. Everybody's using the GAAP principles. Trump was using the GAAP principles all across New York, GAAP. Then all of a sudden, oh, you're fraud. You just committed fraud, and we can now take your buildings from you. What? based on a single judge's utterly subjective and incorrect determinations. It's seizure, it's seizing the means by the government. That's what Tish is doing because she's a communist. Now, the valuation decisions are not only subjective, they're also wildly inaccurate. All right. Areola, the Engeron judge, shockingly valued Mar-a-Lago at $18 million, said it could be as high as $27 million, though, disregarding expert testimony that it's actually worth over $1.2 billion. In fact, recent disclosures demonstrate that Mar-a-Lago, which is debt-free, by the way, generated $56 million. Let's round that up to 57 because it's a 0.9er on that. $57 million in revenue last year. Oh, gosh. And $52 million the year before. That's what it generates in revenue. It's worth $18 million. Furthermore, when tested in the marketplace, other asset sale prices dramatically exceeded the statement and the estimated values that were posted in the financial statements. For example, the old post office sold for about $400 million after Trump estimated it that it was worth $130 million, right? Ferry Point sold for $60 million with a potential escalation to $175 million, but they only estimated that it was worth $22.5 million. So Trump is undercutting his actual numbers. So President Trump, by the way, also Tish, is one of the most successful developers in the history of New York. Skyline has his print on it. He rebuilt the New York skyline, created thousands of jobs, rescued and rejuvenated historic Woolman Rink, developed the $3 billion West Side rail yards from 59th to 72nd in Manhattan, was deeply involved in developing the Jacob Javits Convention Center, and is singularly responsible for many other successes. The lawsuit against him vindicates no public purpose at all. And furthermore, Tish, President Trump will soon take office as the 47th president of the United States of America. You better believe that, baby. Thus, the continued pendency of this lawsuit raises grave and doubtful constitutional questions and gravely disserves the national interest. In fact, 24 years ago, President Clinton's Department of Justice emphasized the hazards of allowing criminal enforcement actions to go forward against the sitting president. Clinton's attorneys reasoned that the president is the symbolic head of the nation. To wound him with a criminal proceeding is to hamstring the operation of the whole government in foreign and domestic affairs. The federal special counsel's office relied on that, and even Jack Smith, who's not even a real boy, could figure this one out, Tish, and voluntarily dismissed his case. The same concerns arise here. This is a civil fraud enforcement action. Jack's was criminal. This is even less than that. Where 6 of the 7 causes are based on allegations of alleged violations of criminal law. So here it would be perilous to permit this action to move forward against the president because it would risk imposing burdens that would make it impossible for the president to do his job. And likewise, the supremacy clause of the federal constitution also prevents state prosecutors from proceeding against the sitting president in any way. States have no power to retard, impede, burden, or in any manner control the operations of the federal government. In fact, the Supreme Court case reaffirmed that in 2020, saying the Constitution guarantees the entire independence of the general government from any control by the respective states. That's Trump versus Vance. It also follows that states also lack power to impede the president's execution of those laws. And so under this principle, under the supremacy clause, judges and prosecutors are prohibited from interfering with the president's official duties. Now, you can imagine where we're going with this. Fannie Willis is going to get a letter like this soon enough. In his farewell address, a long time ago, my friends, President George Washington warned against, quote, the alternate domination of one faction over another, sharpened by the spirit of revenge natural to party dissension, which in different ages and countries has perpetrated the most horrid enormities. Such factional division and strife, President Washington warned, ultimately leads to the ruins of public liberty. As a modern statesman and icon of the Democratic Party, President JFK also stated, the time has come for intellectuals and politicians alike to put aside those horrible weapons of the modern internecine warfare, the barbed thrust, the acid pen, and most sinister of all, the rhetorical blast. Let us not emphasize all on which we differ, but all we have in common. Let us not consider not what we fear separately, but what we share together. President Kennedy's vision of unity applies here. Letitia, on October 3rd, the time of our nation's greatest division, 1863, President Abraham Lincoln issued his Thanksgiving proclamation, establishing the national holiday that we celebrate this week. President Lincoln called for the American people to set aside their bitter divisions so that the blessings of liberty could, quote, solemnly, reverently, and gratefully acknowledged, become as with one heart and one voice by the whole American people. Lincoln urged all Americans to fervently implore the interposition of the almighty hand to heal the wounds of the nation and to restore it, as soon as may be consistent with the divine purposes, to the full enjoyment of peace, harmony, tranquility, and union. Invoking the same spirit of unity, Letitia, we request that you stipulate to the vacatur of the judgment and dismissal of this case with prejudice and get rid of it. Sincerely, your soon-to-be new Solicitor General, D. John Sauer, on behalf of President Trump. And so that dropped into her office. We'll see what she does about it.